Further hearing in the appeal A against R.
Mrs. Derbyshire.
Good morning. If I might start this morning with dealing with the homework which I was set overnight. Yesterday I was asked two questions. A question by my Lady Hale in respect of how the High Court came to have jurisdiction parens patriae, and also a question by my Lord Mance as to the effect of the 1583 order being an order in council, therefore made by virtue of Her Majesty's royal prerogative, and whether that would confer or delegate that sort of jurisdiction. The answers to those two questions are, I think, closely linked. Essentially, and I apologise for this horrible summary of many centuries of law, but historically, the king was the fountain of justice. He established courts to apply the law and to determine disputes according to that law. And that, we say, is what the Queen directed should be done in Sark. In fact, the 1583 order was a direction to the Royal Court in Guernsey, who then went on to establish the Sark Court by way of ordinance. But in any event, that was a court of law applying the ordinary law of the land. Outside of that court system, individuals petitioned the king or the queen for justice. So that was outside the usual law, if I can put it that way. The king or queen appointed a secretary to help them in that task, and that person was the chancellor. The chancellor was also given the function of authenticating documents, principally writs and grants, by way of application of the Great Seal. So the Lord Chancellor is also the keeper of the Great Seal. Of course, the Lord Chancellor came to exercise the jurisdiction delegated to him by the Crown in the old Court of Chancery. And as we all know, the old Court of Chancery became part of the normal court structure by virtue of the Supreme Court Judicature Acts of 1873 and 1875. By dint of those acts, the old jurisdiction of the Lord Chancellor of the Court of Chancery was vested in the High Court and the High Court alone. And that, I hope, answers both questions. We can go back, if it would be of assistance, quickly, just tab 1 of Authorities Bundle 1, just to look at that first order in council again, just so I can refresh the court's memory, if I may. This is MS page 790 and 791. And in essence, I simply want to draw the court's attention to Article the 2nd, which refers to the civil jurisdiction in Sark, the establishment of the court there, the jurats, and compare that to the petition, which is on page 791. So that's a petition from the relevant de Carteret, Philip de Carteret at the time, petition the 3rd, that there might be a seal authentical granted by Her Majesty within the said isle to serve in causes of common justice arising within the same between party and party. That's the equitable jurisdiction, that's the Court of Chancery. And response the 3rd, as to the matter of the 3rd petition, was denied as not expedient to be granted. So we say, to sum up my answers to that question and my submissions yesterday, that the Court of Sark has no inherent jurisdiction to act parens patriae. We say, as I said yesterday, that was the jurisdiction prayed in aid by the respondent. That's not simply a pleading point, however, because it's a jurisdiction that was exercised by the Court of Seneschal and which the Royal Court of Guernsey approved and exercised, particularly in paragraph 50, the conclusion of his judgment. One additional point I would make, and you'll see that this point featured throughout my submissions this morning, is the question of what jurisdictional difference it should make, if any, that the father was in fact supporting his child at the relevant time. So say that you are against me, my ladies and my lords, and you say, no, there is an inherent jurisdiction. The court could have acted parens patriae. Would that jurisdiction in any event be engaged if the child was being maintained at the relevant time? And here we come back to the €4,000 a month that were being paid for the support of the child at the time that the action was brought. So those are my submissions on jurisdiction, ground 1. Ground two I can take much more quickly, and that's the conflicts point. I took you yesterday to the 1852 Ordonnance des biens meubles et immeubles, which is in tab 3 of your bundles. I don't need to go back to that document, you saw it yesterday. But it says, les meubles suivent la personne et les immeubles suivent le territoire. That means that for an action en meubles, the applicable law would be the law of the person who owns the property. And we say that applied to an action in maintenance, were it to apply to an action in maintenance, that would be the applicable law of the maintenance creditor, the mother in this case.
Are you going to deal with the allegation that the law that you say should have been applied wasn't pleaded?
I am, that's what I'm coming to now, my lord. So the respondent doesn't address the substance of this argument and doesn't say if this point were pleaded, it would be a bad one, but says it wasn't pleaded. She focuses on its admissibility, and she says the argument comes to nothing, this is paragraph 65, because the insurmountable difficulty with the applicant's case is that neither the applicant nor the respondent pleaded nor sought to rely on foreign law below. Now I say, to use a phrase which is popular at the moment, that this is an example of having one's cake and eating one's cake. And I say this because the claim began as a claim in the court's inherent jurisdiction. That was the claim that we had to meet at first instance. It morphed principally in the royal court, though not in the conclusions of the court, but in the course of his reasoning, and then firmly was confirmed in the Court of Appeal to be a claim in the normal jurisdiction of the court, and therefore an action en meubles. Now, as you know, we object to that evolution of the claim, and we say that's unfair for a claim to evolve in that way through the court's appellate jurisdiction. But even if the respondent is allowed to evolve her claim in that way, it cannot be said against us that we didn't plead initially the law which would apply to a claim which was only discovered by appellate courts who came to consider the decision of the court of the Seneschal. So this applicable law point, my lord, it arises only if it's an action en meubles, but we weren't meeting an action en meubles at first instance. Our defence is a defence to an action in the court's inherent jurisdiction. When the point arose in the royal court, we then did seek to raise it in the Court of Appeal. My learned friend yesterday said that she was going to dispute that. So could I just take you to the second volume of the record on page 736. So the appellant had raised a host of grounds of appeal, and the Court of Appeal said, no, you have to identify 10 questions which you would like us to answer. This is on page 735 at the top of paragraph 23. They say the 10 questions identified by the father with their many sub-questions. So these are the questions that in his second time round he said, I really want you to consider. And question 4, at the top of page 736, is which law should be applied by the Sark court to the application of the mother, dated 28th of January 2013, that's the originating summons, Sark law or the law of domicile, the country beginning with A or Germany. And then we see in paragraph 24 at the bottom of the page, the Court of Appeal says, question 4 raises an issue about the applicable law that on the 31st of July 2014, the Lieutenant Seneschal decided made no difference to the outcome. But as I say yesterday, that was an error, and we say it was an error in paragraph 7 of our written case. The Lieutenant Seneschal, in fact, determined the law applicable to the question of C's legitimacy would make no difference.
Can you give us a reference?
I can. It's page 465 in this same volume. Paragraph 94. And it's the last sentence of paragraph 94. I felt at that stage I could not ignore the issue and I needed to explore the status that might be attributed by German law. But it seems to me that the status, and here we're talking about the status of legitimacy, attributed to the child C is not of a legitimate child as it is understood in Sark law. Sark law therefore considers the child C as not legitimate.
Yep.
And this is what he's talking about at the time he's talking about legitimacy.
Can you just help me with what is meant by domicile in this context? Are we talking about the common law concept of domicile, or are we talking about the much more universal concept, these days at least, of habitual residence?
So just take instructions on that.
Because domicile is a very technical term in common law, and certainly the country beginning with A would not be the domicile of anybody, as far as I can, on whatever information we have. But G might very well be of everybody, under the English law concept.
I think it's now agreed that the relevant country is Germany, not the country beginning with A. I can take instructions on the way that domicile was.
But I still do need to know whether which sort of concept we're talking about.
I'm told it's the English law technical concept of domicile.
Well, why would that be part of Sark conflict of law?
I think by way of Norman French law,
Yeah, but
the answer I just received. I'm sorry that I'm not in a state to respond to that question now. I can, of course, take instructions over the short
well, we'll see whether it actually turns out to be important.
So if this point is open to you, why is the law of the domicile applicable here?
Because les meubles suivent la personne.
Because?
Les meubles suivent la personne because the movables follow the person. Let me take you to the relevant place in our written case.
And you say follow the creditor. How do we know that as well as part of this declaration, rather than the debtor,
Yes, my lady.
or either?
I can hear that the appellant is speaking behind me, that it's the same for either, but I take your point that we need to know which it is.
I suppose they adhere to the person who is said to own them is the more natural meaning of les meubles suivent la personne.
But maybe if it was a debt, that would be owned by the person to whom it was owed. And that would be
The
then it would be
creditor.
the creditor, wouldn't it?
Yes,
Yes,
exactly.
as
But
an
if it
item
was
of property, yes.
unquantified, it could be owned by the person who has it. at the moment.
The meuble is the right, not the obligation.
Right.
So it would always be the creditor.
Yeah.
But why that means that the applicable law is that of the creditor,
That's a different question, yeah, perhaps. But, I mean, just trying to get it straight, you say this point couldn't have arisen on an inherent jurisdiction basis, because what? The rule, les meubles suivent la personne, doesn't apply to that.
Well,
Something must apply to it.
something must apply to it. That's right.
If
The
it-
only argument we make here is in respect of meuble. I mean,
Yeah.
of course, we say it falls outside the jurisdiction on meuble. in
No, but
any
if
event.
there was inherent jurisdiction, wouldn't one be facing the same question? What is it that, what proper law governs this particular right under the inherent jurisdiction? In other words, shouldn't your side have been directing their attention to the point just as much as they say they did once the meuble claim became apparent?
My Lord, because there is no inherent jurisdiction, there wasn't an obvious article in an ordinance or something like that to which the court's attention could...
Well, that's slightly circular, but
But I take
you
your
were
point.
meeting a claim that there was an inherent jurisdiction. Indeed, I think you're still meeting a claim that there is some sort of customary jurisdiction, and therefore the question of the governing law, one would have thought, would arise. And what appears to have happened is that the parties appear to have assumed that it was the lex fori, which is familiar, at any rate, in this jurisdiction. I don't know whether it's familiar in Guernsey.
I think it's true as a matter of pleading that in respect to the inherent jurisdiction claim, that was assumed. that there was lengthy evidence, as I understand it, from experts in foreign law on the question of the legitimacy or illegitimacy of the child.
Right.
And my understanding, although this isn't in the bundle, is that questions of the kind of payments of maintenance that would be obtained in those different jurisdictions were raised with those experts. So as part of the slightly more amorphous exploration of the various different issues that occurred before the Court of the Seneschal, that issue was broadly within what he was considering, but it wasn't pleaded.
Does that improve your position? I mean, there's no doubt that status is a separate issue, which you would naturally look at the law of something like the domicile to resolve. So there's lots of evidence about that. You say there was some evidence also ancillary about what might govern the right to maintenance, but nobody appears squarely to have suggested it was German law. And why not? I mean, if the issue was touched on, your position seems to me, if anything, slightly weaker.
My Lord, that might be right in respect of the inherent jurisdiction claim. The point I'm making now is really limited to the action on meuble. And it's true that standing back now, looking at the 1,000 pages of the record that we have and the many other pages that we don't have, one can say maybe points should have been taken that weren't taken at different points. But I do say that taking such a formalistic approach to that question now, in particular, if the claim is being allowed to evolve in general, would be rather unfair.
Well, I don't really understand that, because I mean, if the question of the proper law of status was raised in the context of an inherent jurisdiction claim, why wasn't the question of the proper law of maintenance raised at the same time? The fact that the claim is now put under customary law as meuble doesn't seem to alter the obligation on you to raise as the proper law, a legal system other than that of the Lex Vorhae.
But the obviousness of it being a different legal system is much more patent when one has the ordinance that relates to meuble et immeuble.
One can see that to some extent, but what do you say, what incidentally happened in the Court of Appeal when you actually raised this, or was it
they wouldn't hear it because they thought it had been determined. They thought the Seneschal had considered it.
Yes, I see. That's the erroneous point.
That's the erroneous point.
Yeah.
They said, "Oh, you raised it below," and he said,
"So we've really got to decide whether it should be allowed or should have been allowed." Yeah.
Of course, and you have my submissions. The first time it arose squarely, the meuble point, we did try and raise it, and the Court of Appeal wrongly thought it had been raised below and said, "No, we're not considering it." And we say, in those circumstances, it would be rather unfair to preclude us from raising that point in this court.
So how do you jump from les meubles suivent la personne to the choice of law in this child maintenance application is that of the G country?
Well, my Lord, in a sense, I'm arguing against my own position because we say that an application for maintenance isn't an action en meuble. You know, that was my point yesterday. In order for the Sark Court to have jurisdiction, you are going to have to find that it is an action en meuble, because we know that the Sark Court only has jurisdiction over meuble and immeuble, and it's certainly not immeuble. So if it is en meuble, what's the applicable law? Les meubles suivent la personne. So it's the law of the person who owns the obligation. That's the maintenance creditor. So that's ground two.
So what the consequence of this point would, the matter would have to go back for trial as to what German law is?
Yes, but German law, like the law of the country whose name begins with A, is rather straightforward. A, I think, is a pure tariff, and G is just a set of rules. So it would need to be remitted, but I cannot imagine it would be for anything particularly substantial. My understanding, although my learned friend will correct me if I'm wrong on this, is that there's essentially agreement on what that law is, because it's designed to be straightforward.
So would the order be less than £1,800 per month if the G law was applied?
Yes, my Lord.
It would be less?
Less, yeah.
And why would that be?
Because of the law that is... I do actually have a reference. Let me see if I can find a reference to the amounts. I think they're below. Excuse me. I'm sorry about that. Apparently it was at all time agreed what the country beginning with A and German law was, and I can certainly try and find that agreement. I'm told that the biggest difference between the German position and the English position is in the first 3 years, where as a matter of German law, the mother has to be given the equivalent to the wage which she has lost if she stopped working. I'm also told that that was the level which set the €4,000 that was paid by the appellant.
The first 3 years of what?
The child's life.
First 3 years of the child's life.
So that the mother can be at home with the child, assuming it's a mother and a father. I'm being very gendered in what I'm saying. But the person who's at home with the child has the first 3 years at the level of their previous employment. And then the difference between the amount ordered by the Court of the Seneschal and what would be ordered in German law gets closer together. I've been given the figure of around €700, but I would like to go and actually check what the position is before I formally say.
Well, I asked the question, but speaking for myself, don't bother.
Thank you.
And is that on the basis that this is an illegitimate child in German law? That's the rules you're giving us?
I don't think it matters, but I'll take instructions again.
I'm not sure.
It doesn't matter at all, it's a matter of German law.
But in any event, if we make this big leap to les meubles suivent la personne, to that dictates applicable law, according to apparently the English law of domicile, we then have to have some sort of notion as to where the mother was domiciled in English law.
I take that point, my lady.
Perhaps we better move on, Miss Wakefield.
So I know, I'm conscious of time and I hope this would be a relatively short ground, but I'm sorry. I will come back to you on domicile. So, grounds 3 and 4, I'm going to deal with together. Essentially, this is the argument that Sark law does not include a customary law action in maintenance. Now, they're raised as 2 separate grounds of appeal in our permission to appeal document. Ground 3 is on a true construction of the 1583 Order in Council, customary law forms no part of the law of Sark and is outside the jurisdiction of the Court of the Seneschal of Sark, save to the extent that such law has been expressly approved by Her Majesty. And ground 4 is alternatively to ground 3, an action such as that in issue, viz. An action by one parent against another parent for the payment of periodic maintenance in respect of their child, is unknown to the law of Sark and ought not to have been recognised by the Court of Appeal. In overview, in my submissions will take the following structure. Firstly, I'll deal with the point that we say only customary law which has been established or approved by Her Majesty applies in Sark. Secondly, we say that any customary law which has been changed into formal or positive law can no longer be abrogated except by statute. Thirdly, we say that Sark law did not already include an action in maintenance, such as that made in this case, contrary to the views of the Court of Appeal and the Seneschal, although they gave different reasons. And fourthly, we say that the Morton and Paint criteria for developing the customary or common law, which the Royal Court applied, were not fulfilled here. Firstly then, only customary law which has been approved by Her Majesty applies in Sark. So we say that the 1583 Order in Council and the 1594 Ordinance, with their express reference to the people of Sark obeying customs established and approved by Her Majesty, excluded any parallel common or customary law. Instead, for that law to change, there must be legislation, as there can be and as there has been now by virtue of the 2016 Act. I appreciate that, as my Lord Lord Wilson asked yesterday, the 1583 order refers to Alderney. The 1594 Ordinance does not make any such reference. And I would suggest that the correct interpretation is simply that the Queen in Council was saying to Sark at the time, you need to reject Jersey, the court of the Jerseymen, and you need to behave like Alderney. And I say the policy behind this first argument, this locking down of the law in Sark, was to prevent the inhabitants from reintroducing Jersey law under the guise of developing the customary law. The only customary law which has been approved by Her Majesty, obviously there's been much legislation subsequently, but customary law approved as customary law, is l'approbation, and I'll take you to that now. That's in Volume 1, Tab 2. So this is l'approbation des lois, coutumes et usages de l'île de Guernsey. It was completed in 1582 and approved by order of Her Majesty's Privy Council on the 27th of October 1583. At MS 805, we see the beginning of Terrien's commentaire du droit civil tant public que privé observé au pays et duché de Normandie. Then at page 801, we see the approbation. So what the approbation was, I'm sure you know this already, but it was a process of going through the customs that applied in Normandy at the time, 805 and onwards, and saying in respect of Guernsey and Sark and Alderney, which of those customs reflected the customs on the Channel Islands, on those islands, and which didn't. So we see on page 801, livre second, that's a reference to Terrien, then chapitre premier, and they say notre coutume s'accorde à ce premier chapitre. So there we see a wholesale adoption of the first chapter of the second book of Terrien. This continues throughout the customary law. The relevant one for our purposes is chapitre second, and this is on page 801.
Under livre second.
Of the livre second, indeed, my lady. It says, par la coutume de cette île, le père est légitime administrateur des corps et biens de ses enfants, jusqu'à ce qu'il soit marié ou parvenu à l'âge de 20 ans. Et après le trépas de sa femme, so after his wife has died and so on, and then the colon, about 6 or 7 lines down, and the reference which my Lord Hodge made yesterday, maintient le héritage en convenable état et alimente les dits enfants. The next sentence, que si, only if, que si le père ne fait son devoir juridiquement de son administration, on lui doit bailler un coadjuteur ou lui ôter l'administration. So that last sentence is something like forming a remedy. We see the statement of an obligation, and then we see the statement only if the father doesn't do what he legally should do in respect of the administration of his children, can somebody else be appointed and the administration taken off him. Now, we say that this allows for no action to require periodic payments from the father. We say that at its very heart, this is a provision which gives the father sole custody of his children, to which the notion of the mother having custody and being entitled to payments is antithetical. And that's at the heart of our submission.
Am I right that in fact, this relates, in the present case, we're concerned with the period when they were sharing on different days of the week, 2 halves of the week?
When the application was first brought, I think that's not right. They are now sharing.
Right, I see.
The fact
But your argument applies to both, does it? Both periods, even when they were sharing, each taking 1 half of the week, or even as they are now sharing?
So there are 2 points, my Lord. The first is a difficulty with this case and with money being separated off from custody, is a lot of the decisions of custody are themselves contentious and apply this first paragraph. And the status of legitimacy or illegitimacy is seen to be relevant to how this first paragraph would apply. So if the proper reading of this paragraph is that the father has sole custody, then should be...
This can't represent the modern law, can it? It would be contrary to all sorts of principles, international and Human Rights Act, to say that the father is necessarily the legitimate administrator of the person of his children.
So
how would we read the substantive law now if we were asked to deal with the custody matter? Surely we wouldn't read it in the literal sense.
My Lord, could I take you to the first volume of the record, page 130? And I know that this issue has been backwards and forwards, and I'm not properly versed in where it is currently, and it's not before this court. But I just want to show you how the Court of Seneschal dealt with this point. So page 130, and then in paragraph 12, essentially this very point is taken. So the respondent, who is the father, was saying that it had been said against him that he had no powers whatsoever because he was an illegitimate father, so he fell outside the approbation. And essentially here, we see that the Seneschal, considering what I'm going to come to at the end of my submissions, namely the legislative preoccupation with this issue and the fact that everybody knew at this time that the law had been changed relevantly in Guernsey and Alderney in 2008.
So the father was then arguing that as the father of a child born out of wedlock, he had no rights.
Saying that was unfair.
And now he is arguing that he has sole rights.
He says either a father of an illegitimate child falls within l'approbation, so he has all of the rights, or if he falls outside of it, there's no law which governs it, or there wasn't until 2016.
Well, can you help me then? In 2013, when the court in Sark ordered that they share the person of the child, what law was it applying?
I can't help you with that question, but I will come back to that if I might. I haven't looked properly at that limit of the case.
Did your client in October 13, in the absence of the mother, obtain an order for custody, care and control from the Seneschal? Ms. Wakefield?
Take instructions on that, if I may.
Why do you need to take instructions? It's in the précis. Your client, in October 13, in the absence of the mother, obtained an order for custody, care and control. Does it follow that he accepted that the Sark court had the right to make an order for custody, care and control? Does it follow, Ms. Wakefield? And then the next question would be, if it does follow, if the court can make an order for custody, care and control, how can it possibly not have a parallel and incidental order to provide maintenance for the party who is awarded custody, care and control?
I think the answer must be, my Lord, that if the only order which the court was able to make would be an order in favour of the father, and we know from l'approbation, the idea is that it's the father who has custody of his children, the father who alimente ses enfants, then it would never arise that one would make an order for maintenance, because he has the obligation to pay for his children, and he's got his children presently. If that's the only order that was sought, I think that logically must be the answer.
Has the Sark court got the jurisdiction to make an order for custody in favour of the mother?
I haven't sufficiently looked at those documents to see what jurisdiction was prayed in aid there, but it would seem that unless it was meuble or immeuble, as we know, no.
No, very well.
But has your client ever objected to the jurisdiction of the Sark court in respect of custody, care and control?
Am I allowed to take instructions on that one, my lady?
Yes. Oh, that's different.
I'm told that he has objected at all times, but I think on a host of reasons which involve where the matter should be tried.
But
so
he actually,
the jurisdiction.
He actually got an order from the Seneschal, ex parte, didn't he? And he then went and enforced it.
He did, and that was because it was in the strict terms of l'approbation, though I take entirely the point which we canvassed yesterday, that there is conceptually an important difference between jurisdiction to do something and content of applicable law. And it would be perfectly possible for Sark law to contain an obligation, which in fact only the Royal Court in Guernsey would have jurisdiction to consider.
Is there any case law in Sark, Alderney or Guernsey which supports the contention that l'approbation froze the customary law of those islands?
It certainly didn't freeze the customary law of either Guernsey or Alderney. We say it froze the customary law of Sark.
Why can you draw a distinction?
Well, we can draw a distinction because of the argument with the Jersey men. So I should make it clear now, what I'm saying, I'm dealing just with the customary law developing outside of l'approbation, there being no other customary law, not the Snell and Beadle point, which I'll come on to shortly. And the distinction between Sark and Guernsey and Alderney is that Sark have been subject to the takeover of the Jersey men's court.
Yes, but l'approbation didn't just apply to Sark, did it?
No, my lord, that's the Snell and Beadle point. That's the next. The next.
Precisely.
Point.
But what is it in the order that restricts Sark in a way that Guernsey and Alderney are not restricted?
The order only applies to Sark, my lord. It was the establishment of a court in Sark, yes. And the Queen said, and this shall be the law in Sark. The law in Sark will be not the customs as they develop from time to time, not the customs as they are on the island of Sark, but only the customs which I have approved and established. That's only in the 1583 order and the 1594 ordinance, and it only applies to Sark.
Yes. I mean, is there any case law from the Sark Seneschal's Court, the Royal Court, or the Court of Appeal of Guernsey, which has taken the view that Sark, unlike its sister islands, is so restricted?
No.
No. Thank you.
And how does it fit with Article 15, saying that it's going to observe the ancient laws as in Alderney, where Alderney evolves and the rest doesn't?
That was the point that I sought to deal with earlier in my submissions. That I say the best reading of in Alderney, because we don't have Alderney in the 1594 ordinance, the subsequent one. It only appears that first time round.
So it's just to freeze the law as it was then. Is that?
Yes. So Sark should behave as Alderney is behaving.
I.e., being subjected to the laws of Guernsey rather than Jersey?
Yes, but also freezing them so that by dint of the behaviour of the people on the island, the customary law of Jersey couldn't re-emerge in Guernsey. That's my argument for why Sark is different from the other two islands. Sorry. So that's the first point.
Curb the rebellious to Carterets, one of whom I notice is recorded as being in prison at the time of the relevant one of these orders.
Yes, they were imprisoned.
Yeah.
But why could it not equally mean that the law of Sark would develop in line with the law of Alderney and Guernsey? Why would it not equally mean that? It's a much more obvious meaning of behave as the people of Alderney behave. And if the law in Guernsey and Alderney develops, why doesn't the law of Sark develop consistently with it?
But customary law doesn't develop. If it's not endorsed by a coutumier or by legislation, it doesn't develop.
That's a different point.
That's a different point, of course. Yeah. But if it's developing just in the sense of customary law, which is pleaded in a court of first instance, which one has to adduce proof of normally, it would be just limited to that island. It could easily be limited to that island or to Alderney or to another island. And if Sark were allowed to say, oh, well, that's all very interesting, thank you for your approbation, but you know, actually the way we do it on our island is X, and then to immediately begin tracking its own course through its own customary law again and departing from the other islands, that would vitiate the intent of the 1583 order and 1594 ordinance. So, secondly, this is the Snell and Beadle point, which the appellant has been urging me to move on to for some time now. The Snell and Beadle point is simply that any customary law which has been changed into formal or positive law can no longer be abrogated. Now, this is standard. It was established, as you will all know, by Snell and Beadle in the Privy Council in 2001. We have that case in the second volume of the Authorities Bundles. I may not take you to it because I hope it's common ground. It's tab 31. And Lord Hope said in that case that as soon as custom is changed into formal or positive law by judicial decision or by statute, it ceases to be custom. It ceases to evolve or develop by usage and practice. And nothing they, and then he was referring to the coutumier, contained could be abrogated except by statute. We see a similar statement in Dawes. Again, I'm not going to take you to it with my eye on time. That's in volume 5, tab 62, page 2338. And he says, there's a powerful argument to suggest that l'approbation had a stultifying effect on Guernsey law, an effect which is still felt today in those areas most heavily influenced by customary law, i.e. land law and inheritance. Because
Sorry, where are you quoting from?
This is Dawes, page 2338. The point, I hope, should not be a contentious one in the principle. The contention will be how it applies to this case. So 2338, that's behind tab 62 for those using the hard bundles. And he simply says, because l'approbation had become an order in council, it was treated as a largely immutable statement of Guernsey law. By contrast, Jersey law was freer to develop. And of course, Snell and Beadle was in fact a Jersey law case. But it is, as I understand it, common ground, as it must be, that nothing which changes l'approbation could arise simply by way of usage and practice of the islands, that it would have to be changed by statute. And we say simply that the development of a cause of action in maintenance, such as that sought in this case, would impermissibly trespass over l'approbation, in particular that part of the second chapter of the second book of l'approbation.
But why? I mean, the father has an obligation to maintain, and the court has a power to appoint someone else to look after the child. How is any of that contradicted if an alternative remedy of maintenance at the suit of the carer of the child, i.e. the mother, is developed? I mean, where is there any abrogation involved in that?
Yes, my lord, the standard position is that the father has custody of his children, he les alimente. If he breaches it, then the court can step in certain limited ways. If he doesn't breach it, and if the mother simply goes to the court saying, can I have a binding court order, please, compelling him to do something, footnote which he's already doing, then that is contrary to l'approbation.
Are you saying there is no customary law now in Sark because it's all been formalised?
Yes, that's my first submission. My second submission, which is, in a sense, in the alternative, because obviously I wouldn't need it if I'm right on my first submission, is that even if there is customary law, following Snell and Beadle, it can't trespass over or abrogate l'approbation. And if that leads to results which we are unhappy with, then it's quite easy to change, because of course I'm saying that the chief pleas can simply legislate, as indeed they have done now in 2016, having not copied the other islands in 2008. My third argument is that the Court of Appeal was wrong to hold that Sark law already included an action in maintenance. Now, the Court of Appeal relied upon two sources of material which it said demonstrated that the customary law of Sark had already developed a power to award maintenance. This is in the second volume of the record, at page 741. In paragraphs 42 to 45. Firstly, the court relied on an 1868 law called Loi relative à l'entretien des enfants illégitimes, That's in volume 1 of the authorities bundle at tab 4. Which is MS 824. And essentially this deals with the prescription period, which would apply to an action in maintenance in respect of an illegitimate child. Now, this was repealed by a 1927 law, which we have in tab 6. And the 1927 law was enacted in Guernsey alone. Tab 6 is 837 in the electronic bundles.
Sorry, which 824 is the 1868 law?
It is. And then 837 is the 1927 law, which repealed that earlier law. And the 1927 law, which establishes the statutory cause of action in maintenance in Guernsey, doesn't apply to Sark.
So this 1868 projet continues to apply in Sark.
No, it was repealed entirely, as I understand it. I mean, that was certainly the view of the Court of Appeal, I think.
When was
But
that?
it's premised on the existence of a cause of action.
That exactly was
That's
the
the
point.
point,
That was the
isn't it?
point of the Court of Appeal. That they said, well, you wouldn't have a prescription period if there wasn't some cause of action. And we say, well, that's as maybe so far as Guernsey is concerned, but there's been no evidence of any statutory cause of action or common law cause of action to which this referred, certainly not in Sark.
But doesn't the projet apply to the whole bailiwick?
Yes. Well, the 1868 projet de loi does. I think you accept that.
We do say that it's been pointed out by the appellant sitting behind me that there's no reference in the beginning section to it passing in front of the chief pleas or anything to do with Sark. And normally you do see that in legislation that applies to Sark. So you see it's formulated by Guernsey and then it's considered by the separate legislature of Sark, and there is no reference there. The Court of Appeal held that it did apply to Sark. We say that the application must, in the light of that, at least be doubtful. Though I would fully accept in my written case. We say that it does apply to Sark.
You say it does?
In the written case, we say it does apply to Sark.
And are you still saying that?
No, my lord. We're saying that that must be doubtful because there's no reference to the chief pleas or the legislature of Sark. So in the page and a half, setting out the legislative course of this projet de loi, it doesn't pass in front of anything to do with Sark. So that was the first of their two sources. The second source is a record of a case in which the Court of the Seneschal has in the past awarded maintenance. That's set out in paragraph 44 of their judgment on page 741. Now, as we say in paragraph 73.3 of our case, this case relates to an action between two representatives of two minor children, one of whom appears to have impregnated the other. It's between the two representatives. And we say it's not really an action in maintenance like the one that the court is considering today.
Can we just look at it? Just remind me where it is.
So this is in paragraph 44.
No,
Yes, but where's the actual case?
Where's the case?
The case isn't in the bundle.
Is it tab 14?
No, it's definitely in the bundle. It's illegible. It's cut off at the side and is in French, but it is there with an appeal.
Yes, my lord.
14.
It might be more helpful, perhaps, if I just said to the court that we are, of course, aware that there are more cases, recent cases, in which orders, on occasion, some of them looking like orders in maintenance, have been made by the Sark Court. That's something which I'm sure my learned friend is going to refer to in her submissions. Those are the cases which were exhibited to the witness statement that was filed last week. Now, I'll deal with those cases, if I may, in reply, because I haven't heard what my learned friend's going to say about them yet, but we do object to the witness statement which accompanies those cases. Now, I took my Lady Hale's point yesterday about authorities, but they were found only last week. They weren't before any of the courts below.
Well, they're either authorities or they're not authorities. If they're authorities, we don't need evidence of them.
Well, they're authorities wearing two hats, if I can put it that way. I think they're being submitted as evidence of quality of law and the fact that, in fact, everyone could have found out what the law of Sark was if only they'd gone and looked.
But that's a separate issue. The amount of time that Advocate Barnes took to find them may be a question of fact to which an objection can be taken. What he found, however, are authorities.
Grateful, my lord. Well, in that case, there's probably no need for us to look at this particular case. The short point I make...
Well, it might, if we're going to deal with the judgment below, we ought to have a brief look at it. I'd just like to clarify where it is. I've certainly read it. Here we are. I've got it. 1011.
Tab 14.
Yes, it's tab 14.
1011. Yeah. I mean, as far as I can see, it's amongst other things for expenses, but it definitely concludes with 2 shillings 6 pennies for the maintenance of the natural child of the said Jenny de Carteret until she attains the age of 16 years. And what is slightly mysterious is why the order was set aside, but perhaps one has to read a considerable amount into the words that la dite Jenny de Carteret a été publique à plusieurs autres, which is slightly sad.
Yes, well,
It's very sad, isn't it?
people do say those sorts of things.
Yeah, anyway, assuming that's so, it has nothing to do with the jurisdiction to award maintenance.
Doesn't, my lord, but in that particular case, we would say it's relevant that, as we suggest in our written case, it's something close to an action in tort, perhaps, that it's 2 minor children, one of whom caused loss to the other one by causing them to become pregnant and having the child that they then had to support. And so it's cast as an action in damages more than anything else. This is in 73.3 of our written case on page 27. And we certainly say it isn't an action in maintenance,
Well,
a
I don't know
standard
if
action in maintenance. Like
why does it matter? It's meal or malt. It's effectively it's covering the maintenance one way or the other. We shouldn't be too tied by the precise way they put it. Where's the jurisdiction come from is the question.
I think it does matter that it's a person in the control of one person committing a wrong that causes loss to another person. That profoundly changes the analysis. If we're thinking about l'approbation and about the duties of a father in the language, the gendered language of l'approbation, a father towards his family and the family unit, this case isn't about a family unit.
But you don't find any concept or discussion of the tutors having failed to keep a proper eye on what was going on. It doesn't seem to be based on that. It seems to be based on the fact that there was a natural child and maintenance should be ordered. The tutors were acting as sort of guardian in bringing the litigation and in defending it, but I may be wrong.
My lord, you have my submissions. I say simply this isn't the exercise of a standard family law style jurisdiction. Yeah. It's something different.
But, Ms. Wakefield, in paragraph 59 of one of his judgments, the judge in the Royal Court refers to a case called Points Baker, 2007,
yes,
where maintenance was ordered for a non-marital child. And, of course, one of the new cases is Williams and Martin, again 2007. Maintenance is ordered for a non-marital child. Don't keep us in suspense. Tell us in a sentence what your submissions are. I think they are. Those orders were made without jurisdiction.
Those are my submissions, without jurisdiction, and also in breach of the relevant law. That Sark law doesn't permit those orders to be made.
Yeah, so you take a jurisdictional point and you take a point about absence of legal right.
I do. I would also just say something, if I might, quickly, about the difference between customary law and common law. And they seem frequently to be used interchangeably, but I would say that in truth, coutume, customary law, is, as described by Lord Hope in Snell and Beadle, the product of general accepted usage and practice. And that isn't the same as judge-made common law. So I entirely see how, and we're going to come on to, how when a coutume exists, the courts might develop it. What I struggle with is how the practice of the courts themselves could create a coutume. I'm instructed that coutume normally needs to be proved as a fact, and that the practice in Guernsey is to have an enquête in which 12 witnesses are called to testify that common usage and practice has developed. In Guernsey, the witnesses are normally advocates, so you call that apparently a consultation du barreau. And that's how it's proved, rather than looking at instances of courts taking the same view that they had jurisdiction previously. I have got a case with you, an old Privy Council case, which I will hand up if I may.
Thank you.
And I rely on this very simply for the second paragraph. It's the Gold Coast Colony. It says the land law in the Gold Coast Colony is based on native customs. As is the case with all customary law, it has to be proved in the first instance by calling witnesses acquainted with the native customs until the particular customs have, by frequent proof in the courts, become so notorious that the courts take judicial notice of them. And that's the simple point I make, and I'm instructed that that's the position in Guernsey in respect of customary law, the establishment of customary law, rather than its development by courts. Fourthly, moving away from the Court of Appeal, the Lieutenant Seneschal, he too held that there was already a customary law right to a maintenance action, but he did so by reference to the 1976 report. Now, I'll take you to that judgment. It's at page 483 of the record, which I think will be in the second volume. In paragraph 11, he says, in previous aspects of this case between the parties, I have held that the law in Sark is largely reflected in a report that was presented to the States of Guernsey in 1976. He then says certain aspects of the customary law referred to in that report have changed, and in particular the welfare of the child is now recognised as being of paramount concern. Now, if I take you to that 1976 report, that's in volume 5, tab 69.
So which judgment is this, please?
This is the Lieutenant Seneschal. So
when?
the case...
Which one?
Oh.
It's the March judgment, isn't it?
It is 5th of March 2015. So we see, over the page, on page 485, you see he moves straight onto paragraph 15. It's necessary now to consider the level of maintenance. Then in paragraph 25 on page 487, he sets out the various things which he's awarding maintenance in respect of. Storage costs in Austria, food costs, property tax, rubbish charges, and so on. Okay, tab 69 in Authorities Volume 5 is the report of the States Committee investigating the rights of the father and mother of minor. Now,
Sorry, could you give me the page reference again?
oh, sorry, I apologise.
2410.
2410, thank you. Now, I would draw the court's attention to paragraph 12 which is on page 2413, which says, under the law of Guernsey, neither the mother nor the natural father of an illegitimate child has the legal right to the custody of the child or to administer the child's real and personal property unless appointed by the ordinary court as the child's guardian. In practice, the mother will have de facto custody of that child, and no one would normally be appointed guardian of her child without her having been given the opportunity to be heard by the court. And then this is the important sentence. The natural father may be ordered to contribute to the support of the child where an affiliation order has been made against him. And then paragraph 50, which is on page 2423, we see the payment of sums by way of maintenance for an illegitimate child by his natural father is a matter which is already governed by a law of 1927, empowering the magistrates' court to make affiliation orders. That law of 1927 is the one I took you to earlier, which applies only in Guernsey, which allows for affiliation orders, allows for maintenance payments, but is limited only to Guernsey. And we say simply that the Lieutenant Seneschal was wrong to look at that report and to say, well, that then sets out customary law in Sark. Finally, I come to Morton and Paint. We say that the criteria in Morton and Paint, which permit judicial development of customary law in Guernsey, would, if that approach applies to Sark, not be fulfilled here. We've seen that the Court of Appeal said an action of maintenance already existed, and we've seen that the Lieutenant Seneschal said effectively the same thing, but by reference to Guernsey statutory law. The Royal Court, in contrast, at least in part, applied Morton and Paint. I'll take you to that. It's at page 588 of the second volume of the record.
Oh.
Paragraphs 47 to 48.
The case itself is at 1450.
Yes, my lady. I'll be taking you the case as well. So if I take you to Morton and Paint, which is, as you say, at 1450. So the first point to note, of course, is that this was a Guernsey case which concerned occupiers' liability, and which, of course, does not feature in l'approbation, and in which the law of occupiers' liability was developed to abolish the distinction between an invitee and a licensee. Now, we see on page 1477, this is just beneath the little extract, the citation, Judge of Appeal Southwell says, long-standing and fundamental principles...
I'm sorry, please give me that page reference again. I was making a note while you said
1477.
1477.
My point here is really, we've already looked at l'approbation and about Snell and Beadle saying, well, you're locked down to l'approbation, even when developing customary law. And I'm relying on this paragraph to show that, in fact, even if it's not locked down in l'approbation, if something is a long-standing and fundamental principle, it also can't be developed by judicial decision. That's what Southwell is saying in this paragraph. That case, that's referring to Singleton and Lenoury, concerned the property law of Guernsey. Long-standing and fundamental principles of property law could not be overturned by judicial decision today.
Can I just draw attention to his first sentence? You referred to some authority about the need to prove by factual evidence the development of customary law, but that struck me as odd, and the first sentence isn't really consistent with it. The first sentence recognises that the courts can also develop customary law, doesn't it?
Yep.
Isn't that what one would expect?
That's the distinction I was trying to draw, obviously unsuccessfully, between saying what customary law is, like discovering a new customary law, saying this is how land is dealt with in this jurisdiction, or this is how the family unit is understood in this jurisdiction, and developing it, an incremental development, as we'd be used to in the common law. And I do say that the courts have jurisdiction to incrementally develop customary law. But I say that if it's being said, oh, nobody knew before, but in fact, Sark does have customary law that allows there to be an action in maintenance. That would have to be proven as a fact, and the courts could then develop it in the normal way.
I mean, supposing the courts took the view that the approbation was a bit old-fashioned in its, and that in its modern application it couldn't be taken literally, would it be incremental development if they started to work out how it should apply in a situation where you couldn't say that the father had sole custody, or perhaps where you weren't dealing with a legitimate child? Would that
Not if it's contrary to the plain words of l'approbation.
No, but I see, you say that you're locked. Yes.
I do say you're locked, and in particular that last sentence, que si, only if, that says clearly the circumstances in which the courts can intervene. Excuse me.
Yeah.
I'm reminded that, of course, l'approbation has the status of primary legislation. It was endorsed by Order in Council. So, of course, it would be subject to the normal Section 3 interpretational obligations and so on. But it couldn't be significantly developed or changed otherwise than by primary legislation.
We're aware of that. Well, at least we're aware of that it has the status of legislation. What does Justice Southwell mean by referring not only to the coutume, but also to the common law of Guernsey? He appears to acknowledge that there are two different things there.
He does appear to acknowledge there are two different things there. The case, as it has become, is a case about a customary law jurisdiction. If it's right that Morton and Paint applies to development of the common law as well as development of customary law, and they are in fact one and the same, then we would see, I would think, that Morton and Paint limits the powers of the courts in Guernsey in respect of common law in a way that might perhaps be surprising to us. I read Morton and Paint as applying to all customary law development, and it imposes those 5 aids of navigation. And of course, the common law normally, when one is in front of a court, one doesn't always run through those 5 aids to navigation if one is asking for the common law to be slightly developed. So I find that surprising, but the case I understand against me now, if it's moved from inherent jurisdiction, is one about customary law, not common law, if there is a difference in the Channel Islands.
Well, yeah.
Now, on page 1476, you see that Justice Southwell adopts Lord Lowry's 5 aids to navigation to be applied in the Court of Guernsey just as much as by the English courts, bearing in mind that development of the civil common law by the courts is more readily undertaken than of criminal common law. But this applies in particular and always, as I understand it, to development of the customary law. And we have those 5 aids to navigation, which were on the previous page, 1475, in the smaller text. 1, if the solution is doubtful, the judges should beware of imposing their own remedy. 2, and this is particularly important in the present case, of course, caution should prevail if Parliament has rejected opportunities of clearing up a known difficulty or has legislated while leaving the difficulty untouched. 3, disputed matters of social policy are less suitable for judicial intervention than purely legal problems. 4, fundamental legal doctrines should not lightly be set aside. And 5, judges should not make a change unless they can achieve finality and certainty.
Ms. Wakefield, on 2, you said it was very important. There's been no known difficulty about an order for child maintenance until your client took this point, has there?
Could I hand up these minutes of the chief, please, in 2006? Just a single page. They do have them. Sorry, could my learned friends have the spare one? I'm sorry. So this is an extract from the official minutes of the Chief Pleas issued by the Seneschal and Gref of Sark in respect of a meeting on the 18th and 19th of January 2006. If we turn over the page, item 17, report on maintenance orders, reciprocal enforcement, bailiwick of Guernsey law 1984. At present, Sark is outside the reciprocal arrangement between states for the enforcement of affiliation orders. The Sark court cannot make orders for maintenance, but we are asked if we will enforce those from other jurisdictions. In fact, the court is being asked to act as a debt collector, and so on. So I rely on that for the understanding of the legislature at that time. Historically, we know, of course, the Act of 1927, which you have in your bundles, which I've taken you to, was Guernsey law. I'm told that the standard position is that laws such as that would be circulated to Alderney and Sark, and they could decide whether to opt in or opt out, as it were, and Sark did not adopt that law. We've also, of course, got the Children, Guernsey and Alderney Act 2008. That is behind tab 12 in volume 1 of your authorities bundle. And if I could direct your attention in particular to section 21 of that law, I will find the page reference to you. That's 976. And in section 21B, well, section 21A empowers the court to make interim orders. This is relevant to my final ground of appeal. 21B says any order concerning financial provision for or on behalf of a child. And then we see the previous statutes which allowed those orders to be made, 2 in Guernsey and 1 in Alderney. Now, Sark did not sign up, as it were, to that law. That was in 2008. Instead, Sark waited and enacted its own law in 2016. And that is in the next tab, 13. And we see, relevantly on page 994, acquisition of parental responsibility by unmarried fathers. And then 1007. We have the equivalent provision to section 21 in the other act, section 19, where the court has power to make a section 16 order. It may make A, an interim order at any stage of any proceedings, giving the Sark court power to make that order, and B, a financial provision order.
Could you please just give me the...
1007.
Thank you.
Sorry. So we say that the position from the point of view of the legislature at least seems to be tolerably clear, that they didn't take opportunities which were offered up to create this cause of action, that their view, certainly is recorded in those minutes of the session of the Chief Pleas, is that the Sark court could make no order for maintenance, that they didn't sign up to the 2008 law, and that they did finally in 2016 enact their own law allowing for these sorts of payments. So that's the second of the Morton and Paint criteria. As to the other
And what
ones,
do they mean by family proceedings?
my lady, is that the minutes you're referring to?
No. Section 16.
Section 16. I'll go back to the beginning of the Act. Lady, I'd have to trace you the Act to see if those words appeared elsewhere. As a matter of jurisdiction, I would say that for the financial provision order, that arises under Section 19. Section 16 empowers the orders on which Section 19 is piggybacking, if you will. But I see my lady's point about family proceedings and how that fits into MERB and IMERB, and I will go through with that in mind.
Section 19.5 says the schedule shall have effect in relation to financial provision orders. You haven't given us the schedule, but of course this doesn't apply directly, and you are implying that we needn't trouble ourselves with the, as I understand it, list of considerations relevant to an assessment of child maintenance.
My lord, I think it was omitted in error, actually, from the
I see.
authorities bundle, and I understand my learned friend has got copies. I haven't considered that yet, I'm afraid, but please infer nothing from its absence from the bundle.
I see. Very well.
It had been agreed that the entire Act would be included, but you'll see at MS 1009, it just stops mid-sentence.
Well, I
it's
did
just
see
an error
that.
in copying.
Indeed.
And we do
indeed.
have full copies available.
Thank you.
So, running through the other Morton and Paint criteria, the doubtfulness of the solution, we say whilst the basic point that a parent should provide for his or her child might be easily stated, we say the crafting of that particular obligation, in particular when we have the approbation, it is less easy to do, and still less is the crafting of the appropriate cause of action. For example, to whom is the obligation owed, by whom is it actionable, what are the conditions for its action, is prior breach necessary, how does it interact with the care and custody of the child that we have in approbation, how should quantum be assessed, and so on. In this regard, I would just quickly say, in respect of Kehoe, now, yesterday the point was put to me a couple of times by my Lord Hodge, I think, well, surely if there's an obligation, there has to be some kind of remedy. And of course, in Kehoe, we know from the judgments of Lord Hope, in paragraph 29 on page 1699, who was endorsing the views of Lord Justice Ward in the Court of Appeal. That's on page 1643, in particular paragraph 7. That their view was that there was a gap. You had a common law obligation to maintain your child, but no remedy at common law. And my Lady Hale, whilst dissenting in that case, and not of exactly the same views, if I may put it that way, nevertheless, I think, said that there was a problem with enforcing any common law obligation of maintenance as a matter of English common law, that there was a remedies gap, and that had been filled in this jurisdiction, or not filled entirely, I know in Kehoe, but that statutory action had been taken, both in the private sphere and the public sphere, but that had always been done by way of statute, rather than by way of crafting a straightforward common law cause of action in maintenance.
Yes, but the customary law of Guernsey, or the common law of Guernsey, is very strongly influenced by civil law, and there's a principle of civil law, ubi jus ibi remedium. If there's a right, there's a remedy. So the English parallel may not be precise.
Well, the word itself of l'approbation seems to depart from that, my lord, doesn't it? Because of the cursi. It imposes an obligation, then it says, but only if it's breached.
Well, cursi applies to giving someone else the power of administration, does it not? It doesn't say that there isn't an obligation to aliment.
Yes, cursi is where the father has been given administration of the person and goods of the child and hasn't done his stuff.
Yeah.
But does it follow that if you don't give the father administration, there's no remedy?
We say, my lord, that the proper interpretation, I won't bore the court with repeating my submissions again, but the proper interpretation of l'approbation is that the father has custody and control and aliments his enfant, and if he is alimenting them, as the appellant was, that's the end of it.
It deals with one narrow situation, and that's all, and one type of breach, and that's all.
Yeah. The second criterion, I've dealt with the involvement of the chief pleas. The third criterion as to disputed social policy, again, different approaches might be taken. For example, whether maintenance should be primarily administered by the state or by private enforcement, and if the latter, then how. As to fundamental legal doctrines, the notion of pouvoir paternel was perhaps outdated and slightly unpalatable. It's fundamental to l'approbation, and it should not be set aside otherwise than by the legislature, which they were perfectly able to do. The final criterion, the decisions of the courts below have not caused certainty and finality. To the contrary, as you will doubtless have seen through working through the various judgments, each of them decided that there was a customary law right, or there should be a customary law right, on different bases. And it remains entirely unclear what the shape of that right might be. And in particular, this question of whether the obligation need be breached before the court could be seized. So those are my submissions on the content of Sark customary law. My fifth ground of appeal, because those were 3 and 4 together, relates to the quality of law requirement under the ECHR. So the same complaints we have in respect of certainty and finality when developing the customary law, those that I've just set out, also sound, we say, as human rights complaints. And we say they're complaints that engage really the rule of law itself. As is well known, I won't take the board to silver in the United Kingdom, but the quality of law requirements under the ECHR require that the law be adequately accessible and sufficiently precise. And we say that the law relied upon in this present case fails to meet those requirements. Firstly, we say the existence of a customary Sark law of maintenance was deduced by the Court of Appeal from obscure materials. You'll recall the 1868 prescription provision that was then repealed, and even the application of that provision is, on closer examination, unclear. And an unpublished case, which we say is scarcely relevant and looks more like a tort case or something of that nature. It's notable, of course, that the Royal Court did not refer to, nor was it apparently even aware of, those materials. And we're now told, of course, that there are other cases which could have been obtained, but never were obtained in any of the courts below. We also say the basic parameters of the Sark action for maintenance remain wholly obscure, and I've run through our various concerns to whom the obligation is owed and so on. So in short, we say that the approach is simply too unknown and too movable to be lawful. In paragraph 52 of her written case, the respondent says that the making of a maintenance order simply doesn't engage the rights under the ECHR, the relevant legislation in Guernsey. And so this point doesn't arise. And she relies on the view of the House of Lords in M and the Secretary of State for Work and Pensions. I don't think I need to take you to that case. It's behind tab 42 in Authorities Bundle 3. And Lord Bingham at page 1787 said in that case that such maintenance orders were altogether remote from the sort of abuse at which Article A1P1 is aimed. Now, of course, Strasbourg took a slightly different view, and I'll take you to that case if I may. I've got copies here to hand up.
Thank you.
So paragraph 48 of the court's judgment, which is on page 21.
What was this case about?
This was the discrimination case about a homosexual mother living with her lesbian partner and I think new children who was paying towards her children.
Oh, that one, yes.
When they were,
yes.
yes. So it was, as it was before the House of Lords, it was an ambit case because it was an Article 14 case.
Yeah.
But I'm relying on paragraph 48 because that says that the payments were contributions. I read that not as an ambit point, but saying they are, as we know, contributions are something which have to meet the fair balance test and have to have the quality of law requirements. So paragraph 48, The court has also had occasion to consider another aspect of the UK's child maintenance system in the case of PM in the United Kingdom. At issue in that case was the tax allowance available under domestic tax legislation at that time that was granted to separated and divorced persons with maintenance liabilities. The government accepted that the situation fell within the ambit of Article 1 of Protocol 1. While no issue of taxation arises here, the court considers that the sums which the applicant paid out of her own financial resources towards the upkeep of her children are to be considered as contributions within the meaning of the second paragraph of Article 1, payment of which was required by the relevant legislative provisions and enforced through the medium of the CSA.
Yes, but in England, there is a scheme for a statutory scheme for child support enforced by a government agency. Here we're dealing with what is said to be a customary or common law obligation on a father to aliment his child. I can see why the one might give rise to contribution, but I don't see how the latter fits very neatly into A1P1.
My lord, there is obviously a host of complicated case law about the applicability of A1P1, in particular horizontally between private parties, how the common law falls within A1P1. What I'd say is that the present case bears the hallmarks of a state interference, in particular because of the fact that the father had not yet breached his obligations at the relevant time. So this isn't a case in which there was a private obligation and a cause of action arose upon one party not meeting his obligation to the other. Instead, it's a case in which a mother went to the court and said, I have this obligation, the father has an obligation, he's presently meeting it, but please issue a court order setting an amount which he is compelled to pay me, and breach of which will be breach of a court order. And that sounds to me much more like state interference than a classic private law action would. So I say that that's close enough for contributions.
Could I just ask you precisely when he stopped paying?
When?
Yes, he was paying, I don't need the actual date, but he was paying when the proceedings were issued. Was he paying by the time the order was made?
My lady, could I ask, there was a witness statement on Sunday afternoon which we sought to lodge with the court, and my Lady Hale indicated a hostility of the court to evidence at this stage. Now, it was put in a form of a witness statement. That was my decision, and it was quite possibly, in retrospect, an error, because it's a point that can be made by way of submissions. And it's this, that there is a very short SFI in this case, because the facts are disputed by both sides and cause
well, I don't need a specific one, but you mentioned the relevant date, and I've been wondering what the relevant date is for the provision that you do agree with in the approbation, which is that if the father isn't paying, then there is a power to do something about it.
My lady, if we look just at the first page in the first volume of the record.
So he was paying when the proceedings began, yes, and at some point he stopped paying. Was that before the order was made? That's the simple question.
Before the order was made?
Yes.
My lady, I think it'll be easier if I can put something in writing. I'm told that he paid at all times, and he paid money even after he stopped paying the €4,000. But that
well, you understand, I'm only trying to take a legal point, not one to argue about the facts. Because if, in fact, he had stopped paying by the time the order was made, then if the relevant time is the moment at which the order is made, this approbation provision would apply.
I understand that there is no point at which he was not paying unless he had sole custody of the child.
The only time he didn't pay was when he had sole custody.
Exactly. Putting it more comprehensively.
And that is after the ex parte order on the 4th of October. Well, it wasn't ex parte in the sense that she wasn't, that she did know about it, but she wasn't there.
It was on notice by ex parte. Yes, I think.
And the concept of not doing his duty means paying nothing at all. Is that your argument? If he's just not paying enough?
it would be not alimenting them sufficiently, I suppose. It may, of course, be that alimentation in that sense may frequently have been goods, meuble in the sense that we're much more familiar with, an obligation to feed, clothe, provide shelter to the child.
But if the court takes the view that a higher order is necessary, it could be said that he's not doing his duty, not fulfilling his obligation.
I don't think it could be, my lady. I'd say that if the court said, well, it's an agreed fact, it's pleaded in the short document, he is paying £4,000 and €4,000, and if the court was operating against that factual background, I don't think it could be inferred from the fact that the court made an order, especially not when the amount that it ordered was so much less.
Well, that's why I'm asking about the pattern of payment, because it's a central part of your case that this provision was not satisfied in this case.
It is, and I will find out the pattern of payment, in particular by reference to the period up until the order.
Yeah, please, if you wouldn't mind. Thank you.
Well, as it's a matter of fact, it's either got to be agreed between you or not. I'm afraid we're not hearing evidence, we're not deciding disputed issues of fact. If this was thought to be relevant to your argument, well then it should have been put forward at an earlier stage. It's not for us to determine disputed issues of fact. So you've either got to agree something with the other side, or we will make of it what we will.
And on to my sixth and final ground of appeal. I've been racing ahead. I think I will sit down fairly shortly, so my learned friend should be ready to spring up. This relates to the...
I'm sure she's grateful for the warning.
I know. Interim orders. On the 14th of August 2013, the Seneschal made an interim maintenance order against the appellant. That's at page 183 of the bundle. On the 19th of December 2013, the Royal Court added further maintenance payments. That's at page 385. On the 9th of July 2015, the Lieutenant Seneschal gave a judgment ordering payment of over £28,000 of arrears in respect of those interim maintenance payments. That's at page 503. In his public judgment, the Deputy Bailiff said, and this is at page 581, that the court's inherent jurisdiction extends to making interim relief orders. And then the Court of Appeal dealt with this argument at page 744. Now, it focused on the case of Angenant and Pring. These are in paragraphs 54 to 55.
Well, this presumably was the submission that was being made against the payment of interim orders.
It is, and I'll take you to Angenant and Pring shortly, if I may. But I just want to show you the decision of the Court of Appeal. By reference to Angenant and Pring, it was submitted that because the Royal Court does not have jurisdiction to award interim payments, the Court of Seneschal should be found not to have any such jurisdiction, and that therefore the Court of the Seneschal could not have made the orders for interim maintenance payments which founded the Lieutenant Seneschal's judgment of 9th of July 2015, £28,000 for sums ordered but unpaid. In his public judgment, the Deputy Bailiff considered and rejected the father's submissions concerning the impact of Angenant and Pring. The latter case concerned the ability of a court to make an order, in the absence of statutory provision, for payment on account of a liability which is yet to be established in pending proceedings. The orders for interim maintenance, on the other hand, are themselves orders determining the obligation and quantifying the liability of the person ordered to pay the amount in question on a continuing basis. They are not for payments on account of a future liability. Now, we say that's a mischaracterisation of what the interim payments were. The father had raised fundamental objections to the order being made, not least the power to make the interim payments order itself, but of course questions such as the legitimacy, jurisdiction, the applicable law, everything that came up on appeal. And the interim payments were interim payments in a standard sense. They're interim payments, contingent payments, in the period until the question as to whether maintenance could be ordered against the father was finally determined. And so we say it's simply wrong to say that this isn't a normal interim payment. It is, it's an entirely standard one. Angenant and Pring, which is in tab 38 of volume 3, is about payments on account. What's relevant, however, in that judgment is that the Royal Court said it was adopting the English law approach. So if I can take you to that judgment, and then I'll take you to the English law approach. So that's tab 38. And on page 1721, the Royal Court says that it has no inherent jurisdiction to make an order for an interim payment in favour of a party to civil proceedings before the court. So that stated as a proposition which would apply to all civil proceedings. And then in paragraph 29, second sentence, the Royal Court is matter of its own procedure, but unless circumstances such as those in Morton and Paint arise, i.e. where the court expressly extends the common law of Guernsey judicially as part of the evolutionary growth of the law, circumstances in Mayo, I consider that the court has no other inherent power to do what it thinks is just and fair. In my judgment, Guernsey law mirrors, in this respect, the English law position on interim payments dealt with by the Court of Appeal in Moore and in the Fouesson-Maroux before the expansion of the English interim payments regime by further amendment of the rules of the Supreme Court in the late 1970s. And if I could take you to Moore, that's at tab 21 in Authorities Bundle 2. And the short point is that this isn't a case about payments on account, that interim payments can't be read down as applying only to payments on account. This is a case in which the landlords, I should say, sorry, the page number is 1179, my lady. The landlords brought actions against tenants claiming forfeiture for breach of covenant and mean profits. And they sought an interim payment on the basis that either they'd win and be entitled to those profits, or they'd lose and be entitled to rent. And at the bottom of page 1183, Sir John Pennyquick rejects that proposition. He says, the court has before it a claim by the landlords based on forfeiture, claiming profits. I do not see any ground on which the court, having only that claim before it, could make an order for interim payments based not on the landlord's claim in the action, but on what would be the position if the landlord's action failed. It may at first sight seem attractive and fair that the court should make such an order, but I do not know of any ground on which the court could be said to possess that jurisdiction. And then he goes on to say, this conclusion is, I think, reinforced by more than one consideration. In the first place, although this position must be one of everyday occurrence, yet no authority whatever has been cited in support of the proposition that the court possesses this jurisdiction. So far as I am aware, there is no recorded case in which the court has ever made such an order. It's true that there's also no recorded case in which the court has ever refused to make such an order. I suspect that that is because, until the present case has not been considered, there would be any prospect of obtaining such an order. And then down by G, he says, on all these grounds, it seems to me that the claim advanced upon these appeals is one which cannot be sustained. It seems to me that the court has no power, either under any express rule in the rules of the Supreme Court or under its inherent jurisdiction, certainly not under any statute, to order such an interim payment, nor is there any judicial authority for saying that the court has such a power. The answer must be the court does not possess such a power, and therefore the judge decided these appeals rightly in dismissing the application. So we say that the Court of Appeal, in our case, was wrong in saying that that Angelent and Pring was limited only to payments on account, and that instead a court needs to be given the power to make an interim payment, so a payment in a case in which the liability to pay has not yet been determined, as in our case. So that is my 6th ground of appeal. Unless I can be of any further assistance, I will sit down with a long list of points to consider overnight and address you tomorrow.
Could I just ask a question going back to the quantification of the maintenance? What was the evidence from your client about his means?
So I'm told that evidence wasn't submitted about income, but was about expenditure, including very sizable credit card bills and other costs, which showed how much he could afford.
I said means, and that wasn't sufficiently focused. What was the, I apologise. What was the evidence about his assets and income?
None was requested and none was given. He says that it would have been known to the parties that he owned a property on Sark. Obviously, there are only 600 people who live there, so the Seneschal would have known that he owned his house on Sark, property on Sark, but he gave no evidence.
Thank you.
We will adjourn for a moment or two to see where we are. Ms. Gallagher, we are principally interested in what you have to say on grounds 1 and 3 and 4 together. You may, if you wish, touch lightly on the other grounds, but in case there's anything you particularly want to draw to our attention, but that's where our interest focus is.
Coincidentally, my lady, the speaking note I've prepared is very similarly focused, and I was in fact intending to take this afternoon, assuming I was going to be starting at 2 o'clock, focusing on grounds 1, 3, 4 and 6, which I thought naturally fell together, and I was intending to take the vast majority of my time with those and then to touch lightly on a number of other issues. So I'm very grateful for the indication, and I will attempt to shorten some of the other points. Before I start my substantive submissions, I wanted to make one preliminary point underpinning the case and underpinning some of the frustrations that a number of us in the courtroom have felt this morning in the way some matters have developed. And I will then tell you the route I propose to follow and briefly outline the submissions that we're going to make. I'm very mindful of the fact that there are pleaded 7 grounds of appeal before you, many of which involve interpretation of documents spanning some 5 centuries, and many of which relate not to the Court of Appeal's judgment, which is under appeal here in this final Court of Appeal, but to the rulings below it. And I had thought there was a lot of ground to cover in my 3 hours. I may be able to shorten it. And can I give you an indication after the short adjournment about whether I can conclude by 4? I think I may be able to conclude today, if that would be of assistance, and cut out half an hour, or there may just be a few minutes needed in the morning to carry over. But I don't think I'll need the full 3 hours in light of the indication given. The preliminary point that I wanted to make is that the Judicial Committee of the Privy Council is sitting here as a final Court of Appeal 5 years after this matter commenced. And what is appealed is the very short, commendably short, we say, decision of the Court of Appeal contained at volume 2 of the record. I ask you to turn it up. MS 731 to 745. It's 14 succinct and accurate, we say, pages, which was quite some feat in the circumstances. And within that, the key passages, we say, are contained within a single page. And they are on pages 741 and 742, paragraphs 41 to 45. At 45, the Court of Appeal says, "It appears, therefore, that the jurisdiction to award maintenance is of long standing, and we've no hesitation in holding that it was available to the Court of the Seneschal when the orders now appealed against were made." And our submission is that this case needs to focus on those findings by the Court of Appeal, and that much of what has been raised is simply not properly before you. So a range of issues to do with inherent jurisdiction, parens patriae, and so on, relate in reality to the lower courts, and they were filtered out by the time we got to the Court of Appeal, and the focus should be on those 14 pages. I will touch on some of those other issues. I intend to do so lightly in the circumstances, given your role. I intend, in terms of route and summary submissions, to set out the Respondent's case under 4 broad headings, and I hope this will accord with what my Lady Hale has just indicated. Firstly, and this will be the vast bulk of my submissions, I intend to address the remit and role of the Court of the Seneschal of Sark, addressing both the various jurisdiction points and the appellant's submission that customary law forms no part of the law of Sark and is outside the jurisdiction of the Court of the Seneschal of Sark, save to the extent it has been expressly approved by Her Majesty. So that encompasses the appellant's ground appeal 1, 3, 4, and 6, but I intend to take 6 very shortly, and that will take the majority of my time. These 4 grounds of appeal we have thought it would be sensible to take together, because in our submission it's wholly artificial to divorce the question of jurisdiction of the court and the creature of statute argument which is advanced against us on the one hand, ground 1, from the argument that the April 1853 order in council set in aspic Sark customary law, such that customary law is outside the jurisdiction of the Court of the Seneschal, save to the extent it's been expressly approved. That's ground 3. And we say there are 2 closely related critical grounds of appeal, and that's where our focus will be in these submissions. And I hope that will assist.
You say 1853?
1583, I think it was an inversion of the...
I'm so sorry. Did I misspeak and give a wrong date?
I think you did.
I'm so sorry.
That's okay.
It's 1583. I'm
Very well.
To the April 1583 order of council. I will also take you to the October 1583 order, to which we haven't yet gone, because that's also very relevant when it comes to this matter. But it's relevant both to the jurisdiction argument and to the argument about customary law, and I hope I can assist you on those. And in brief, our submission is that the appellant's approach to both of these grounds is wholly flawed, and this is why we described it as being without merit in our written case. In a very telling exchange yesterday, counsel for the appellant was asked, I think by my Lady Black, whether the Court of the Seneschal of Sark is effectively a court for the enforcement of debts, and her answer in essence was yes. And our submission in a nutshell is that nothing could be further from the truth. The Court of the Seneschal of Sark is a court of unlimited jurisdiction in civil matters and limited jurisdiction in criminal matters. The documents before the Judicial Committee show that it has been recognised as such since 1583, although there is some prior history to which I briefly intend to take you, much of which has been encapsulated in a very short number of paragraphs in the Berkeley case by my Lady Hale. It is widely and unanimously considered to be a court of unlimited jurisdiction in civil matters. There is no judicial, academic, or other commentaries supporting the appellant's surprising and radical position, and the sole page indoors which they rely upon is simply a misreading of that passage, and I'll show you why. Its unlimited civil jurisdiction has in recent years been confirmed in a series of pieces of legislation, most recently the Reform Sark Law 2008, and the Court of Appeal was quite right to describe its jurisdiction in this way. On customary law, the entirety of the bailiwick of Guernsey, including Alderney and Sark, has long been understood as possessing a customary and common law jurisdiction. I'll come to the question that was raised about whether there's a distinction between customary and common law in my submissions. And that was and is capable of development to reflect societal changes. And the idea which appears to be advanced, which is that in April 1583, the customary law, as it applied in Alderney at the time, was frozen in time, snapshot of April 15th, 1583, applied solely to Sark. And Guernsey and Alderney, the remainder of the bailiwick, could continue to develop that customary law, and Sark was frozen in time, is nonsensical and simply not borne out by the documents. And the appellant's interpretation of the 1583 materials more generally as singling out Sark from the remainder of the bailiwick as having a far more limited jurisdiction in civil matters is wholly flawed and without foundation. And furthermore, we shall say that the common law of the bailiwick overall and of Sark has long included an action for maintenance against the parent of an illegitimate child. I'm using that language because it's the language of the material, it's not language I endorse. And it has rightly been developed so as to afford a remedy to a parent in the position of the respondent mother in this case. And indeed, the absence of such an action for maintenance would in any event infringe the obligations on the Seneschal of Sark under Section 6 of the Human Rights Bailiwick of Guernsey Law 2000. But I can touch on that very briefly.
Is that something that, if we got to that point, that we can give effect to? What's the... If the argument is right that the approbation is it and doesn't cover this situation, can we just use the Human Rights Act to override it, or would we have to do that by interpretation?
So we don't accept the argument that the approbation...
No, of course you don't.
We don't accept that. But there is also an alternative way of approaching it, which is even if the approbation at the time did in fact have the effect that's contended for, the fact that there has been a parliamentary decision. Yes, the fact that there has been a parliamentary decision made in relation to the 2000 Act moves matters on. And also, I'm reminded by my learned junior very properly, by Mr Jacobs, that there is in fact a provision for the Seneschal of Sark to grant a declaration of incompatibility. It has the option of granting a declaration of incompatibility. And
so it's the same position
yes,
as in this... But does it count as primary legislation for the purposes of the, whatever the equivalent...
I'm sorry, I misunderstood your question, Lord Mance. I can give you a very short answer to the question of whether the Judicial Committee could put it right, and that is, it's in Authorities, Volume 1, Tab 10, at MS page 884. So it starts at MS page 883 and goes on to MS page 884. And that is about the declaration of incompatibility provisions. And in Section 4, subsection 5A, you'll see that court means the Judicial Committee of the Privy Council.
And what I asked was the approbation, that would count as primary legislation, would it, in this context?
Yes, we do accept that.
Yeah, yeah.
I'm so sorry, Lord Mance. I'm just actually going through the very initial outline.
Yeah.
I hope that's helpful. I just wanted to give a roadmap. And I appreciate I'm not delving into the documents now, and it may be a little frustrating. I just wanted to give an overture so you can see where I'm going with the points. I'll ensure that that point is picked up. I'll pick it up at the end because it would be very, very much a fallback position for us. But I'll pick it up at the end of this first section. I do intend also under this head to deal with grounds 4, that's the ground of appeal to the effect that an action for maintenance is unknown to the law of Sark, and ground 6, the submission that in any event there's no jurisdiction to make an interim maintenance order. But I'll take those briefly. They're plainly linked to those core grounds 1 and 3.
I think when you come to answer Lord Mance's question about primary legislation, you will want to look at section 17 of the 2000 Act at page 900, Ms. Gallagher.
Yes.
Yes?
Thank you, Lord Wilson. And I can certainly ensure that I'm well equipped to answer that question after lunch.
Yeah, no, thank you very much. That's what I was looking for.
I'm very grateful. I also intend to address under this heading, very briefly, the inherent jurisdiction and parens patriae arguments, although in our submission these are in truth pleading points, to adopt the wording of Lady Black in a question put yesterday, drawing on the wording of the mother's original one-page application 5 years ago and the wording of one of the Deputy Bailiff's rulings, rather than, in truth, a challenge to the reasoning of the Court of Appeal, which is the judgment under appeal here. And in our submission, the Court of Appeal was quite right to summarily dismiss the inherent jurisdiction point as an overly technical one. And they said, on any fair reading of the mother's application, the father can have been in no doubt about what she was seeking and why. The cross-reference for that, I don't ask you to turn it up, is Record 2, MS 743, at paragraph 49. Secondly, I intended to turn briefly to the remedy sought by the appellant. The reference for that is MS 754, Record 2. In light of the indication that's been given, I may be able to deal with this just very briefly now and not return to it, if that would be of assistance. I can do it very shortly. So if you go to the second volume of the record, page 754, it says, what order are you asking the Judicial Committee to make? And it says, order being appealed set aside, original order restore, and restore the order of 4th of October 2013. Now, this links to a number of questions which were asked by my Lord Wilson this morning, when my Lord Wilson said to the Appellant's Counsel, well, in October 2013, your client obtained an order for custody, care and control, and if the Seneschal of Sark can grant an order in that way, how can it possibly not have jurisdiction in these parallel proceedings? And this shows precisely the double standards in the submission that's being made by the appellant, because to say that on the one hand they're appealing that one order, but on the other hand they want to restore the 4th of October order without being able to explain how the Sark court, they say, has got jurisdiction to make such an order, causes them real difficulty. And I think, given the indication I've had from the court, I won't develop that any further. The third issue I intended to develop was ground 2 of 7, the conflict of laws point. And I intended to do this rather lightly, and I hope that's in keeping with the indication that's been given. As foreshadowed yesterday, our submission is that this is, in truth, not an appeal point at all, and special leave should certainly be refused in respect of this ground of appeal, or in the event that you grant special leave, the ground should be refused. And the Court of Appeal, from a procedural morass and in the face of great difficulty, boiled down 242 separate grounds of appeal to key points focused upon by the appellant. It is right that there is a reference to it, albeit not formulated in the way it is now, in point 4 of the list of 10 questions. But as I will show you, it was not developed in the submissions. And in any event, the appropriate choice of law was that of Sark. There's nothing before you to indicate a proper basis for making an alternative decision. And it was being designed on the hoof this morning, which is a wholly unsatisfactory way to be dealing with a matter of such gravity 5 years into these proceedings, and when the Judicial Committee of the Privy Council is a final Court of Appeal. And this may link to the submissions I made yesterday about the Court of Appeal on special leave having got it wrong about what the test was, but their frustration was understandable. Finally, I intended to address briefly the Article 1, Protocol 1 challenge, ground 5 of 7. That links to a slightly more expanded, more general rule of law point which has been developed in oral submissions. And our submission is the award of maintenance did not interfere with the appellant's right to property protected by Article 1, Protocol 1, and thus no quality of law issue arises, as there's no prima facie interference with falls to be justified, but in any event, the requirement would be met. So turning to topic 1, and this is the main one, concerning role and remit of the Sark Court. There's 3 documents I wanted to hand up, which I thought it would be helpful to do at this stage, just to speed matters up. So I do apologise for the fact that you're getting papers in this form. I'll explain what the three of them are. Just while they're being gathered. The first one is the remainder of tab 13. I indicated earlier that tab 13 in Authorities Bundle 1 has been miscopied.
Yeah.
Put it that way. Would you prefer that I wait?
Why don't you carry on?
Certainly. I'll tell you what they all are, and then hopefully they will have been
Carry on.
distributed by the time I turn to them. So the first item which I wanted to provide you is Authorities Bundle 1, tab 13. That law cuts out at MS page 1009 in the middle of section 22.
Yes.
And that's an error.
Yes.
We've taken the view, myself and Mr. Jacobs, that it was better to provide you with the entirety of the law rather than simply providing you the page where it stopped. It does mean there's a duplication, obviously, for the first number of pages, but you've got the entire law in one place. The second item is an extract from Gordon Dawes' Laws of Guernsey, following a question yesterday relating to judicial review. And it also includes one other passage to which I'm going to take you now. And then the third item is in answer to a point which has been made this morning, and that is a 1984 law. Do you have those? I'll take you to the relevant parts now.
Yeah.
So if I could first start in the 21st century, and if I could go to an item which was raised this morning by my learned friend. You were taken to this single page that was handed up, minutes from 2006, Christmas meeting of the Chief Pleas, this short item.
Yes.
Yes.
And you were taken to it, paragraph 17, which said that the General Purposes and Finance Committee said in a report, at present Sark is outside the reciprocal arrangements between states for the enforcement of affiliation orders. The Sark Court cannot make orders for maintenance, but we will enforce those from other jurisdictions. And because our learned friend gave us notice that she was going to raise this matter, we had a look at the 1984 law, and you will see at section 27, in the clearest of terms, that section 27.1 says where the application is an application to the appropriate bailiwick court. I'm sorry, I'll wait till you have it. It's at page 44.
Yes, got it.
So 27.1, where the application is an application to the appropriate bailiwick court in the island of Sark for a maintenance order, the application shall be made under and in accordance with the customary law of Sark as applicable to maintenance orders. So there's obviously a number of different ways of reading the minutes and what they were referring to when they said Sark Court cannot make orders for maintenance. Did they mean in this particular circumstance? Did they mean in a particular difficult situation which arises under the 1984 law? But in any event, that is a summary from a report provided in a committee meeting, and the 1984 law, section 27.1, is very clear. The second item then, if we look at...
I suppose I should have asked Miss Wakefield whether, in fact, Pepper and Hart applies to proceedings of the Chief Pleas. I merely say it.
I had a note on that point and decided not to pursue it, and I hope in the circumstances the reason for that will be appreciated, because either way, regardless of what points we can knock out for those kind of reasons, we say the appeal is wholly without merit in any event, and I hope you don't need to get into vexed questions on some of those issues. That's for similar reasons. That's why I don't intend to go to inherent jurisdiction and parens patriae in a great amount of detail. The second issue which I wanted to take you to is in the 2016 law, so the remainder of tab 13, it's unfortunate that you didn't have the full copy because there's 4 items of relevance to the decision which you need to take. I'll take you to them in turn, but just for your note, if you want to take them all down at once, there are sections 34, 37, 42, and then the explanatory notes, the definitions, at page 50. So starting with section 34, that is at page 39 to 40.
So we're looking at...
So it's section 34, it's pages 39 and 40.
The 2016...
So this is the Children's Sark Law 2016.
Thank you, yeah.
So I'm afraid this is the item which was miscopied. So this
Yeah,
should
no,
be
it's
tab
right,
13.
I've got it, yeah.
So it refers at section 34 to the effect of previous sections relating to a variety of matters here. But the reason we take you to it is section 34.2c, which refers to those sections, proceedings, sections 28 to 33, having effect, despite anything to the contrary in C, any rule of customary law or any other rule of law. So that's a reference to the customary law of Sark, which apparently doesn't exist or was frozen in aspic in 1583. It's simply not a viable reading of that provision. To similar effect, if you look at section 37, section 37b also refers to any other enactment or rule of customary law. So that's page 42. And that concerns prohibited degrees of relationship. And then the final section I wanted to take you to is section 42. It's at pages 45 to 46. And it's headed Restriction on Exercise of Court's Customary Law Jurisdiction, where, in relation to any matter or issue, a power created under this law and a power under the customary law are exercisable in respect of the matter or issue by a court. The court shall exercise the power created under this law unless the effect would be unfair or unjust. And that's to deal with the situation that you may have a right, like, for example, a right of maintenance, which is protected in customary law, exists in customary law, but is then enshrined in a piece of legislation, and the presumption is that the legislation applies rather than the customary law, with the saving provision that the customary law could nevertheless apply if the effect would be unfair or unjust. And that's quite in keeping with the Section 6 provision in Guernsey's equivalent, Sark's equivalent of the Human Rights Act. And then the final matter I wanted to take you to is on page 50. It's the penultimate entry, and it says customary law includes the common law. My learned junior, Mr. Jacobs, has done a very extensive piece of work on customary law, common law, what Blackstone said about them, and so on. And we had intended to take you to some of those provisions, but it is clear from this that customary law does include the common law for the purposes of this Act. The third item then relates to the laws of Guernsey extract. And the short point I wanted to take you to in relation to this is on page 38. It's the second page.
Sorry, should we not also look at family proceedings?
Yes.
The question which I raised.
Yes, of course.
That's on page 51.
Yes.
Family proceedings means any proceedings under the inherent jurisdiction of any court in relation to children.
Yes, I'm so sorry. Yes, that's correct. Yes, so that's a total answer to the question which you
It's not
raised
necessarily a total answer. I can imagine what might be said, but nevertheless,
yes,
it answers my question.
yes. And my apologies for missing that.
Where is it? Which page?
So
49, I think. Isn't it?
I'm sorry, my Lord Mance, I think you may be looking for page 51.
I've got
in
to
the,
go back to the statute.
51.
So Lady Hale was referring to page 51 in the
no, I've got it.
2016 law in the definitions section,
I'm with you. Yeah.
where it defines family proceedings.
Yeah.
And you'll see at A, it means any proceedings
Right.
under the inherent jurisdiction of any court in relation to children.
No, I see that.
Of course, it refers to any court. But that may provide, if not a full answer, a partial answer to the question raised earlier. In the Dawes extract, page 38, there's a characterisation by Gordon Dawes in the third paragraph down, which starts, the court of the Seneschal is the sole court of justice on the island. And you'll see 4 lines in, it says, as with the court of Alderney, the court of the Seneschal has unlimited first instance jurisdiction in civil matters with an initial right of appeal to the Royal Court in Guernsey. And then it describes how its criminal jurisdiction is more restricted. And that is the description which was given by the Court of Appeal, quite rightly. It's also the Court of the Seneschal's own description of itself, and it's the Royal Court of Guernsey's description of the Court of the Seneschal of Sark.
Unlimited in what sense? Is that a reference to unlimited in terms of value, or is it wider than that?
No, so it's much wider than that. And I will go back to the documents to show why the characterisation of it being unlimited in terms of value is simply wrong. I thought it would be helpful just to give you, given that some 21st century and 20th century issues arose this morning,
Yes,
I thought it would be helpful to give you these documents so you had them over lunchtime.
Dawes made the same point at page 382, where he said, like the Court of Alderney, the Court of the Seneschal has unlimited first instance civil jurisdiction, save for certain matters reserved to the Royal Court. Again, note the Royal Court's bailiwick-wide divorce jurisdiction.
Yes,
So
precisely.
it's not talking about sum, it's talking about subject matter.
Yes.
Yes.
That's absolutely right. And that's also very much in keeping. I'll come to the 1583 April order. That's entirely in keeping with the language in the April 1583 order, which refers to in all causes, and then has some specific restrictions in relation to ecclesiastical matters and so on. But it's a complete misreading of this body of material to suggest that this is a court for the enforcement of debts. This is a court which day in, day out decides matters like inquests, for example. It's perfectly entitled to decide tort laws, and indeed on one of the cases earlier, the distinction which was drawn was, well, this isn't really a maintenance case, this is a tort case. But similarly, where's the basis for it developing a law of tort? Where's the basis for it determining, in a tort case, an amount of damages, given the argument that's been advanced about what a mobile is, for example? It's a wholly inconsistent and incoherent argument which has been advanced, if I can put it that way, in relation to this issue, and it is entirely at odds with long-standing understanding of what the role and remit of the Court of the Seneschal of Sark is. Now, very heavy reliance is placed on this single quote in a separate section of the Dawes book, which refers to the approbation potentially having a stultifying effect. And I was intending after the short adjournment to take you to that, but it may be convenient just to give you the headline point. Our submission is that it is impossible to read that as suggesting that Mr. Dawes is indicating that the approbation was intended to be stultifying. It's a description of fact that the approbation appears to have had a stultifying effect. And when you read the section as a whole, he's not describing that as being a matter which is correct as a matter of law. He's describing, with some irritation, a factual state of affairs. And that's why I've provided you the very clear indication he has elsewhere in the text. And the indications obviously given to me by my Lord Hodge. There are some other references. I've checked, there's rather a large number of references in the text to it. And we thought this was the simplest one. I should say there's a health warning in relation to this page, which is, this book was originally published in 2003. It has been republished a number of times since, but it hasn't been updated in light of the human rights law change since. So it's worth just indicating that. So at the time when it was brought in, it refers in footnotes to human rights law being pending. But the point which is made here about it having unlimited first instance jurisdiction in civil matters relates to subject matter, not to sums, and there's no proper basis for the characterisation which has been put forward by the appellant.
Yes, I think the same point is made in Ogier at page 201.
Yes, it is. Yeah. I'm conscious of the time. I will try over lunchtime to contract matters because I'm conscious, I assume that the Judicial Committee will be very grateful if we could finish today. If it isn't possible to finish today, I hope we can keep it very short in the morning, and I certainly won't take my full 3 hours.
Well, we would be, of course. We're always grateful if we can finish ahead of the allotted time. But we are to some extent in Council's hands. We will, however, now adjourn and look forward to hearing from you further at 2 o'clock.